Hi, I'm Stuart Hill. For some years I've been trying to establish how Scotland and the UK derived their authority here in Shetland, how Shetland came to be regarded as part of Scotland. My research shows that not only did it not happen, but that it could never have happened, at least legitimately. The courts hold the answer, and since 2008 my energy has been focused there. It's not possible for me to initiate an action. Doing so would immediately mean that I recognise their jurisdiction. So I have to get somebody to take action against me in the courts. Nevertheless, I've been involved in cases at every level in the Scottish system, both civil and criminal, and as high as the Supreme Court in London. In September 2015 there arose the opportunity for another challenge to jurisdiction. The local village shop came up for auction as a bank foreclosure, so I hatched a plan. First of all, I need to explain, all land in Shetland is allodial, which means that the owner is subject to no lord or superior. This is discussed at length in my book Stolen Isles, and I don't intend to go into great detail here, but briefly, if you take the situation in England, where most land is held as freehold, and people think they actually own their land, in fact, the Queen is deemed to ultimately own all land in the realm. She owns the allodial title. Allegedly. The term freehold is short for freehold tenure, just a tenancy. In Shetland, ultimate ownership is in the hands of the people. They own their land outright. The Crown has never claimed the allodial title of land in Shetland. And again, Scots law is quite different to English law, and the terminology is very different. For those not familiar, the sheriff is the judge in the lower court. The procurator fiscal represents the Crown in criminal prosecutions. I hope everything else will be clear. So, coming back to the village shop, the bank involved in the foreclosure was the Royal Bank of Scotland. I'd locked horns with them previously and didn't mind doing so again. I went to the auction and put in the highest bid. This meant that anyone wishing to buy in good faith wouldn't be affected by my actions. As soon as I got home, I cancelled the deposit cheque and withdrew from the sale, prompting the inevitable protest from the auctioneers. I then wrote saying I claimed the allodial title of the premises. I'd already made an undisputed claim for the allodial title of the whole of Shetland, so this was a specific claim under that umbrella. After a couple of weeks there was no response, so on the 23rd of September I took possession. The front door was securely locked, but the side door had no locks and was only held closed by a piece of wood leaning against the inside, so gaining peaceful entry was no problem. I put a notice on the inside of the front door, front window rather, that's this one. Property of the sovereign nation of Shetland, not part of Scotland, the United Kingdom or the European Union. So, I also fitted a pad bolt to the side door. This is a pad bolt. You can see it slides across to lock, and you've got these rings which you can put a padlock in to lock the bolt in either the up or the down position. So this secured the side door. I disabled the front door lock to prevent unauthorised entry by that route. I then sent letters to the bank, the police, the court, the Shetland Islands Council, Registers of Scotland, the Prime Minister and the First Minister of Scotland saying what I'd done. Not exactly the actions of a criminal. I also ran a public notice in the Shetland Times for 3 consecutive weeks announcing that the sovereign nation of Shetland claimed the allodial title of the shop. There could be no doubt that the sovereign nation of Shetland was in possession, and nobody in their right mind could think there was any criminal intent. This was purely a political action. My intention was to provoke the bank into a civil action. What I didn't take into account was the actions of the disgruntled failed bidder, who turned out to be a local solicitor. His actions got the police involved and I was arrested for vandalism, which of course is a criminal charge. As ownership of the shop was claimed by the sovereign nation of Shetland, it was difficult for me to see how I could be charged with vandalism of what was effectively my own property, with no lord or superior. At the police interview, I was very surprised to be shown the notice I put in the window, because it meant that the premises had been broken into, presumably by the police themselves. If that were the case, it meant that the police were involving themselves in a civil matter which was none of their business and outside their authority. After being questioned, I was released on an undertaking to appear in court in October. Meanwhile, the bank and the second bidder went ahead with what, in the face of my claims, I believe to have been a fraudulent sale. This is all about jurisdiction, the authority of the court, so I need to make a small aside here. Back in 2011, I made my first challenge to the jurisdiction of the court on the basis that Shetland is not part of Scotland. The sheriff at that time, Sheriff Napier, to his credit and completely correctly, decided there needed to be a separate hearing on the matter. Having heard both sides, the Crown and myself, he decided he had jurisdiction. I appealed the decision, and Lord Wheatley found in favour of the sheriff. I appealed that decision, and the sheriff again was supported, this time by Lords Bonamy, Easy and Carloway, the most senior law lords in the Scottish system. Lord Carloway is now Lord President of the Court of Session, so he should know. So the whole judiciary was now united and stood behind the sheriff's decision. For the first time in history, a court had made a decision on whether Shetland is part of Scotland. This was now the established legal position, and upon it rested the whole authority of Scotland and the UK and Shetland. Unfortunately, the so-called proof the Crown had produced was a magazine article by our local archivist entitled "When Did Orkney and Shetland Become Part of Scotland? A Contribution to the Debate." Even its author didn't pretend it was any kind of legal proof, but as I said, the Scottish judiciary were united in their support of the sheriff's decision, and this should be the settled position in law. The whole authority of Scotland and the United Kingdom in Shetland rests upon a magazine article. You couldn't make it up. So when it came to the case, I pointed out in writing that Sheriff Mann should not be eligible to hear my case because of previous history. He had called me a stupid old man on one occasion in court. He demonstrated his closed mind by dismissing a previous challenge to jurisdiction with the words, "Whatever you say, Mr. Hill, I will not be able to agree with you." He'd made me bankrupt, allegedly, after refusing to hear proof of his jurisdiction. He'd put me in police cells on more than one occasion. It was hard to see how I could expect a fair hearing. Nevertheless, the hearing went ahead. Even though this was a criminal case and not the civil one I was seeking, it was still an opportunity to challenge the jurisdiction of the court, which I duly did. I sent a formal notice of lack of jurisdiction, which you can find at www.sovereignshetland.com, sent that to the court and made a verbal challenge on the day. The competence of the notice has not been challenged by any court from the Supreme Court downwards. All they've been able to do is to sidestep it. So Sheriff Mann's proper course of action should have been to rely on the well-settled decision of Sheriff Napier. But after, as he himself said, consulting with Sheriff Napier and the Court of Session, it was apparently decided to abandon the previously established position, and he made the extraordinary claim that he had jurisdiction as a result of the way the people of Scotland had voted in the independence referendum. So, no conspiracy or anything. What relevance that has to the question of whether Shetland is part of Scotland is anybody's guess, but he was now in a very defensive position and apparently contradicting those senior law lords. The formal notice, which should have been the first order of business, was once again ignored, and I was bailed to appear on the 20th of January 2016. The sheriff actually made it a condition of bail that I must not challenge the jurisdiction of the court. This was an extraordinary action which I believe to be a breach of my human rights. If anyone claims the authority to imprison me, I surely have the right to know where he gets that authority. Here's another interesting aside. Section 204 of the Criminal Procedure Scotland Act 1995 is to protect those accused who do not have legal representation. It states that as long as they fall within certain criteria, which I do, they may not be subject to detention or imprisonment by the court. If the sheriff were to put me on remand for 3.5 months, as he was threatening to do, he would be in breach of this provision, and the bail conditions were therefore unenforceable. However, I tend not to think too quickly when under pressure, and my overriding concern at the time was that I didn't want to spend the next 3.5 months, including Christmas and my birthday, in jail. I know I'm a wimp, but I really had better things to do. It's the duty of the Procurator Fiscal to produce all the evidence he has as soon as possible. I didn't get the material until the 8th of January, 12 weeks after the first hearing, and only 12 days before the next one. But even then, it didn't include evidence I'd requested. As I left his office after collecting the material, he suggested that if I made a donation of about £50 to charity, he would drop the case. I politely declined, but it confirmed my suspicion that he had no intention of going forward with it. Close examination of the witness statements when I got them, and the other material, although it didn't include everything I'd requested, revealed inconsistencies, collusion and police criminality in breaking into the building without authority. This was beginning to look like a stitch-up. So at the hearing, before entering the dock, I made a verbal challenge to jurisdiction and was immediately arrested and taken to police cells. Then the sheriff, the clerk, a policeman and a security man then came to the cell to conduct a hearing in the cell, at which I was placed on remand with no bail offered. Within 30 minutes I was in the police van on my way to Peterhead Prison. That's in Scotland. It's 300 miles away, I don't know. Anyway, I made a bail application from the prison and a bail hearing was fixed after 2 weeks of my being in prison. At that hearing I seemingly presented such a threat that I had to be double handcuffed, that is, handcuffed myself and then handcuffed to an officer. It didn't feel like I was innocent until proven guilty. The Crown deserted the case, even though I was keen for it to go ahead. Surprise, surprise, they didn't want all that nasty stuff coming out. The damning evidence supplied by the Crown cannot now come to light. If I release it, I face a stiff jail sentence under the legislation. The 2 weeks in jail were accounted for by the statement that if I was convicted of contempt of court, the sentence would have been 4 weeks. I'd already served 2, so the sentence was served. But curiously, there had been no hearing on the matter of contempt, so no conviction could have been given. When, a few days later, I asked at the court for a copy of the order, I was told there were no papers available to me unless I paid a fee. The whole thing seemed to me to reek of some behind-the-scenes activity. The sheriff has no proof of his jurisdiction, the Procurator Fiscal is withholding evidence, and the police are acting beyond their authority. They're making it up. So after a long and hard think, my solution was to retake the shop, which resulted in a similar pantomime, but I can't tell you about that until the case is over. Whatever's happening right now is just perfect.